Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross LLC. Today we're going to talk about 6 essential business contracts that every small business needs to stay protected. In this video, I'll go through the 6 essential business contracts, what they are, some of the terms that should be included as part of the contracts, and why they're so important for your business. And please, if you'd like to get more helpful tips from us, please hit the subscribe button below and ring the bell to get notifications. Now, before we get into details, I need to get some boring stuff, formal stuff out of the way. Although I'm an attorney, I am not your attorney. Stuff I talk about in this video is not a substitute for legal advice. If you need help with any legal situation or any of these contracts, you should consult with an attorney located in your state. If you're located in Massachusetts and would like to book an appointment with me, I will add links below to contact me through my website, www.brosslawllc. So let's move on to, now that the boring stuff's out of the way, let's move on to the details. Now, recognize that when I'm talking about contracts that a business needs, I am talking about written contracts. First contract is a client agreement. Now, a client agreement can also be called a customer agreement, whatever you call your clients or customers. What a client agreement is just basically a written agreement between you and your client that specifies what it is you're doing, how much you're getting paid, and various other things. This contract should be signed by both your business and your clients before you start providing services to them. There are lots of things that should go into a client contract. Some of the things that you want to include in there are deliverables, what it is you're actually supposed to provide to the client, price, how much are you doing it for, when, the time is when it's going to be provided by you, the location where it's going to be provided, and also payment, how are you going to get paid by your clients. There's lots of other conditions that should go in the contract, but those are just some of the bare things that need to go into your contract and that you should have clearly in writing. Now, the reason why it's so important, one of the main reasons is it makes expectations clear. So what you want to do is when you're forming a contract with a client is you want to make sure that you and the client are on the same boat as to what actually is getting done and when it's supposed to be done. Be surprised at how often confusion arises between the parties about what's supposed to be done, even when it's written. But you want to do your best to set it out clearly as to what's going on so that everyone knows and everyone agrees that this is what's being done by you, how much you're going to get paid, and when you're supposed to do it by. That's the first contract, client agreement. Second contract that every business should have is a non-disclosure agreement or an NDA, or it could be called a confidentiality agreement. It goes under various names depending on the location where you find it. And what a non-disclosure agreement is an agreement where a party is agreeing not to disclose or use your confidential information for any reason except for a limited purpose. Look, the reason why you need this for your business, the reason why this contract is essential to have for your business is because your business likely has lots of confidential information or proprietary information that you want to keep secret and you don't want to be disclosed to other people. And this doesn't have to be just in connection with buying a business, but it can include things like your customer list, any kind of process you have that you consider to be valuable because it's a secret. It could be your employee information, your independent contractors, any kind of things like that that's confidential that you don't want other people to get out is confidential information. And the reason why you want to have an agreement in connection with that is because often in many states, it's a requirement for it to be treated as confidential that you've taken reasonable steps to protect it. And at a bare minimum, a reasonable step to protect it is to have an NDA or a confidentiality agreement that tells people that they can't disclose or use your information for any other purpose except for what you say. Now, the next question you might have is, well, all right, well, what should go, if I need an NDA, what should go into it? Really a lot of clauses that should go into an NDA, and I would advise you to speak with an attorney about it. There's another video upcoming in terms of downloading one off the internet or using ChatGPT. But some of the clauses that should go in there, at least at a bare minimum for a well-written NDA, are something like, first, you need a clear definition of what the confidential information is that you're talking about. And as part of this definition, you want to make sure and identify some of the things you consider to be proprietary and confidential for your business. Another clause you want to have as part of an NDA is a clear statement of what the permitted use is. And what the permitted use is going to depend on who it is that's signing your confidentiality or NDA in this particular situation. For example, if it's an employee that you're having sign an NDA, then the permitted use that the employee has is in connection with doing work for your business. So that would be that they can only use your confidential information when they're performing work for you, not for any other purpose. Another clause you want to have as part of your NDA is a termination clause. And termination clause is a clause that specifies, hey, how does this agreement terminate? And as part of that clause, you also want to specify what happens to the confidential information that the other party has when the agreement terminates. And there are a couple of options here. One is you could require them to destroy it if they can, and then certify that it's destroyed. Another option is you require them to return it. But recognize in this day and age, it's hard to make sure that the other side doesn't have returned everything or destroyed everything because everything's electronic. So you're going to also want to have some clause in there that says, hey, if you have any copy, you still can't use it against us and you can't use it to disclose any competitors. Another clause that you also want to include as an NDA is an enforcement and remedies clause. And this will be a clause that specifies that if there's a breach of the agreement, what rights you have. And usually a common right you want to make sure to have is what's called an equitable injunction, where you can go get an injunction against the other party to stop them from disclosing the information. Yeah. Next question you might be having is, well, who should sign an NDA? And really, anyone who's going to receive your confidential information should sign it. And they should sign it before they get your confidential information. Before I move on to the next agreement, I'd like to just take a brief step to say, if you're enjoying this information I'm providing, please make sure to hit the subscribe button and click the like button and click the button below to turn on notifications. You don't want to miss out what's coming next because we're providing we're trying to provide information here to protect small businesses and entrepreneurs to help you grow and succeed. Next agreement that every business should have, which is what I'm calling a founder's agreement. And so a founder's agreement is an agreement among the people who are starting a business about how the business will be run, who's responsible for when profits will be distributed, and what happens when one founder leaves. And of course, it has a lot of other clauses. Now, although I'm calling it a founder's agreement, it has a lot of different names depending on what type of business you are. So, for example, if you're a partnership, the partnership agreement will have all the clauses you need to have to make sure it's clear about what the partners are doing and when profits will be distributed and who owns what. If you're an LLC and a multi-member LLC, then you should have an operating agreement that has all the details that you need to have what goes in a founder's agreement. If you're a corporation, then you should have some kind of shareholder agreement. So the founder's agreement is sort of the catch-all phrase for all the other agreements that you should have with anybody you're forming a business with to make clear about who's doing what in the business. And the reason why you need it is because, again, you want to make expectations clear about what each founder is doing, how much they're contributing, what share of the business they have, and what share of the profits they'll be entitled to receive. And then what happens if one of them wants to leave? So you want to have this to avoid potential lawsuits in the future, but also preserve friendships and relationships. If you don't make these expectations clear, you're likely the business may be forced to dissolve because it's not clear, or you certainly may have a broken friendship or broken relationship. Now, the next question you might be having is, so I should have a founder's agreement, but what should go in it? I should consult with an attorney about what exactly should go in a founder's agreement because they're going to be particular about what your business is and what each founder is contributing and what they're doing and what they're not doing. But at a bare minimum, a well-written one should have some of the following. At the very least, you want to specify who the founders are and what their address is at the time they're signing. You also want another clause you want to have in there is you want to specify what percentage of the business is owned by each founder. Often if it's two or more, if it's two people, and maybe it's 50-50, but maybe it's not. Maybe one person is contributing more capital than the other, and so they get 70% of the business. And so that should be specified. Another clause you want to have in there is what is each founder contributing to the business to start it up. And again, when I say what are they contributing, this can be different things. So some founders can be contributing cash in order to get, and so any business is starting up, you're going to need someone to be contributing cash. And so what you want to say is how much cash is being contributed by each founder. If somebody is providing services to the business and that's their contribution to the business, that should be identified too. And then what is the value of those services and what are they expected to do and how much time are they expected to spend on the business? If there's any other type of property that's being contributed to the business, that should be identified. Whether it's real estate property, what's the value of it? Intellectual property, if somebody's contributing something that's that's already trademarked or copyrighted, that should be identified. And then what the value of those items And there's lots of other clauses that go in here. I'm only just touching on some of them. Next question you might have is, well, who should sign it? Every single founder should sign it. And they should sign it as soon as possible after the entity is formed, because you want to do it before problems start arising in the business, because once feelings get hurt, it gets harder to negotiate these things. And especially when people start digging in about, oh, well, you didn't do this, you were expected to do this. And then there's disputes back and forth of, no, that was never part of our agreement. So you just want to do it as soon as possible before problems start arising. The next agreement that every business should have is what I'm calling website terms and privacy policies. And so I'm sort of combining this. They're really separate contracts, but I'm combining it as one, because their agreements are located on your website and govern the use of your website. And they do different things. But if you have a website in this day and age, who doesn't? You need to have website terms, or called terms of service, terms and conditions, and a privacy policy. The reason why you need website terms and conditions or terms is because you need to specify the important conditions regarding. And if you're, and this is not just for e-commerce companies, but if you're an e-commerce company, you need to definitely specify what are the terms of sale that are occurring in connection. What are people's rights in terms of buying your goods? Do they have rights to return? What are those rights? But even if you're a service business that's not necessarily selling, you still want to have terms and conditions, because you want to specify what it is you're offering and what state's law governs your website, and is the information on your website binding. You still want to have various caveats included on that to just make it clear. The website reaches everyone in the world. So if you don't provide terms and conditions on your website, you run the risk of having the rules and laws of some other jurisdiction governing and applying to your website. If you're a Massachusetts business, you don't really want that. If you do business in Massachusetts, you want to specify Massachusetts law applies. Now, privacy policy, the reason why you need one of those is that it's required by law in a lot of jurisdictions, including California, Connecticut, I believe. The EU certainly requires it. I know that if you advertise, I believe on Facebook, you're required to have one, or through Google, you're also required to have one. So you're required to have a privacy policy by lots of different places. And so you need to have one on your website. So the next obvious question is, all right, well, what goes into these agreements? So website terms and conditions, I've already mentioned a little bit, but you want to address certain in your website terms and conditions. You want to address certain issues like what choice of law applies, what forum a lawsuit can be brought in. And so usually it'd be the state where you're located. You also want to have various disclaimers of liability, like that you're not necessarily responsible for the accuracy of what's contained on your website. You could also have limitations of liability that specify that what kind of damages somebody can obtain if they rely on your information, your website, and various things like that. So there's lots of clauses that can go in your website terms and conditions. Consult with an attorney in your area who knows something about this. Privacy policies, the details of what goes in there are basically dictated by the jurisdiction which requires it. So, and they can vary by jurisdiction to jurisdiction. So if you're worried about a California privacy policy, you need to have the details that California requires, and they have their own specific requirements that you need to include as part of your website. And if it's the EU, you have to also have various clauses in there to satisfy the EU requirements. But generally speaking, a privacy policy should explain what type of personal information you're collecting, what you're doing with the information, and what rights people have in connection with it, and how long you're going to keep it for and what you're going to do it for. So there's lots of things that should go in a privacy policy. So speak with an attorney if you're not sure. Now, next question you might have, well, who should sign these website agreements? And really, signing the agreements is a little bit weird because nobody's signing them. They're on your website. But what you want to do is you want to make sure that they're conspicuous on your website and they're obvious so that nobody can claim that they didn't see them. And there are various ways to do this. You can run banners across the top that identify that's a little obtrusive, which is what you want, but it destroys the purpose of what your website looks like. So you may not want something like that. A lot of businesses don't, but usually people have them at things at the bottom, but you want to make sure that's readily identifiable. And if somebody's contacting you through your website, or if somebody is ordering goods through your website, you can also have like a click box or something that identifies that whatever they're doing is subject to the terms and conditions on your website and the privacy policies on your website. So it's clear then you've gotten some kind of contractual signature or what can be a binding signature to indicate on your website. So that will work. Next question you might have is, well, when should I have these? And you really need to have them as soon as your website is launched. And they're probably going to be updated as you go along because things change, especially privacy policies. Maybe you change how you do your business. So you want to put a date on what those agreements are and then hold on when you revise them, notify users on your website that's been revised, hold on to the old versions you had. but just put a revision date on them and the date that they're governing. Same thing for the terms and conditions, not just a privacy policy. So you put a date on when they're effective, time when they're revised and effective. Next agreement that every business should have is what I'm calling an independent contractors agreement. Now, an independent contractor agreement is an agreement between your business and a self-employed individual or company that defines the terms of the working relationship and clarifies that the individual is not employed. Like any vendor you hire to do something for you, you should have a written independent contractor agreement with them. Or anybody, if you hire an SEO company to do some work for you or someone to design your website, you should have a written agreement with them. That's what I'm thinking of as an independent contractor agreement. And the reason why you need something like this is you need to clarify exactly what the person is doing for you, how much you're paying them. Also want to specify that they are not an employee of yours and they're not entitled to receive your benefits, and also that they're responsible for paying their own taxes. And so these are essential clauses that should be in an independent contractor. But a related issue that you want to make sure, the reason why you should have an independent contractor agreement is regarding your intellectual property. Oftentimes, you'll hire an independent contractor to do things like to design your website, to create a logo for you, to create blogs for you, or things like that. And what you want to do is you want to make sure, as part of this independent contractor agreement, to make it clear that even though they're doing this for you, that you own the intellectual property afterward. If you don't have a written agreement that says that, dispute for it. As copyright, so under copyright law, this is what's known as a work for hire agreement. It needs to be written in order to be binding. You want to have part of your agreements to say, hey, even though you're creating this for me, my business still owns the intellectual property afterwards, and that I have the right to use it in any way I see fit on my website, in my marketing, and any other way that I want to use it. So you want to make sure agreement that says that. I talked about some of this. The question you might have is, well, what should go into these independent contractor agreements? There are lots of clauses that should go in here. I'll talk about a few of them. You should have things like a scope of work as part of these agreements. The scope of work is going to identify what the tasks they're doing for you and the deliverables. It should have a clause in there that certifies that they're an independent contractor, their status as an independent contractor, and that they are responsible for paying their own taxes. They're responsible for, you want to have obviously payment terms. Similar to a client contract, you want to make sure it has payment terms as to when it should be done. As I mentioned, an intellectual property clause, you want to have in there that who owns any intellectual property created. Business owner, you want to specify that you are the owner at the end. Intellectual property is created for it. There may be some exceptions, but generally speaking, any work product they deliver to you or any deliverable, you should own the intellectual property of that. So probably want to include some kind of confidentiality clause if you're not going to have them sign an NDA. Speak with your attorney or have an attorney review whatever form you've downloaded off the internet or had ChatGPT generate for you. Who should sign this? The agreement should be signed both by your business, a representative from your business, and also a representative from the independent contractor. Both parties should sign, and both parties should retain a copy of the signed agreement to make sure that they have it at the end. And it should be signed before the independent contractor begins doing any work for you. So the next agreement that's going to be discussed is a commercial lease. So a commercial lease is an agreement that you have with a building owner to rent your office or shop location. The reason why you need this is and to provide certainty to you about how long you're renting it for. And so a commercial lease, we'll talk about the terms of a commercial lease and what should go into it in just a minute. But one of the things that's going to be in the lease is a term as to how long you have the space for. And so you want to have that in writing, because otherwise the landlord, if it's just oral agreement, the landlord can basically terminate at any time. And this is one thing that's really very different, at least in Massachusetts. It's very different between residential leases and commercial leases. Residential leases are highly protected under the law. And so even if a lease is oral, a landlord still has to follow certain procedures before they try and evict you. Commercial lease between businesses, almost none of those protections. So you don't want to leave it just up to chance and just have an oral agreement with your landlord. You want to have it in writing. So your landlord can't just terminate it on their whim if they decide they want to rent your space to their brother-in-law who's now needs a new location for their business. Now, the question you might have is, all right, what should go into commercial lease? And again, they're complicated and a lot of different terms. So speak to an attorney in your area about what exactly should go into your agreements and what shouldn't. Just generally speaking, some of the clauses you want to have that should be addressed is, first and foremost, who is the landlord? That should be identified exactly. Who exactly is the landlord who's renting you the space? And you need to be careful here because sometimes corporations that own the property and rent the property and different ones that rent it. And so it can get complicated. You want to make sure and have the right one who owns the property renting the space to you, or at least identifying who that there's permission to do so. Obviously, you also want to identify who the tenant is, and this should be identified. It should be in the name of your business, whether it is as a sole proprietor, as an LLC, or a corporation. Whoever the business is renting the space should be identified as the tenant in the business. Another clause that you want to be in that you want to make sure goes into commercial lease is the space should be identified exactly. So when I say the space should be identified, ideally, there should be layout of the space attached as a lease, but or it should be just specified exactly how much space you're renting, the exact location you're identifying, what office you're identifying, if it's a subset of a business, and things like that. Another important thing that you want to have in the commercial lease is what price you're paying for rent. Obviously, if it's a multi-year lease, the price is going to escalate over time. So that should be identified exactly how much is going to escalate over time and what the rent is for each year they're going to rent. You also want it to be clear as to what other things you're responsible for other than just paying rent. For example, it's very common to have what's called a triple net lease, which basically means that as the tenant, you're responsible for rent, but you're also responsible for property taxes. You're also responsible for the landlord's insurance and basically anything else in connection with the lease. So you want the lease to specify exactly what it is you're responsible for and when you'll know what these fees and charges are so that you're clear about what you're renting and what you're not renting. Another common clause that should be discussed in your lease is common areas. What type of common areas are there as part of this location and what rights you have in connection with them and who's responsible for taking care of them. All this should be specified in your lease. Similarly, landlords and lessees' responsibilities, all these clauses, these all need to be spelled out and they should be particular to your situation. They should all be in writing. And consult with a local attorney that your commercial lease is clear so that when your business is renting the space to use for your business, that you have some certainty about how long you're doing for and how much it's going to cost as much as you can. So to recap, every business needs to have these 6 contracts listed here. Getting these in place early can save you a lot of stress on your business and also serious money down the road because if you don't have any of them, you could end up in lawsuits governing them, trying to clarify certain things that should have been taken care of beforehand. So make sure and get them in place as soon as possible. If you want more videos like this to keep your business legally protected and growing strong, don't forget to subscribe and drop a comment on your questions. I'm here to help you build smart ground up and to protect your business as much as I can. So please subscribe, hit the subscribe button below and ring the bell, and I'll see you next time. Thanks so much.